Let's kick this saga off with a bang, or in this case, a bite. Because yes, believe it or not, one dog bite has unleashed a courtroom battle so messy, so layered, that it's now shaping up to be the HOA versus insurance showdown of the season. Forget Netflix dramas, this is where the real teeth are. So here's the stage. California's Palisades Homeowners Association number 3. Sounds harmless enough, right? A bunch of houses, a board that argues about grass length, and a couple of CC&Rs nobody actually reads. But lurking in this suburban paradise was a pit bull owned by residents Adam and Erica Grun, and this pup wasn't playing fetch. According to the lawsuit, their dog allegedly bit a child, Lulu Pietro Ecovo. And if you know anything about insurance claims, you already know when teeth sink into skin, lawyers sink into paperwork. And that's where the fun begins, because here's the twist. This isn't just a case of the dog did it, the owners pay. Oh no, the HOA itself got dragged in. Why? Because in this community, pets are more than just furry family members. They're a liability on 4 legs. And according to the HOA's governing documents, yes, those snooze-fest CC&Rs, the association is also on the hook when pets cause problems. Boom! Suddenly, the HOA is sitting at the defendant's table right alongside Fido's humans. Now, in a normal world, this is where insurance quietly steps in. After all, that's why people buy policies, to protect against disasters, lawsuits, and the occasional canine catastrophe. But in this case, it turned into a blame-shifting circus. Enter 2 heavyweight insurance players, USLI, United States Liability Insurance Company, Liberty Mutual or its related entity. And guess what? They're not teaming up. They're fighting each other. USLI says, "Hey, Liberty, this is your problem. The dog belonged to your insureds, so you should defend the HOA too." Liberty fires back, "Excuse me? The HOA isn't an insured under our policy. Nice try, but we're not covering them." And just like that, a pit bull's bite spiraled into a full-blown insurance turf war. Let's pause here. Why is this such a big deal? Because insurance companies are like that one friend at dinner who suddenly disappears when the check arrives. Everyone wants the benefits, but no one wants to pay. In this case, USLI doesn't want to carry the entire defense bill for the HOA because it believes Liberty should step in first. Liberty doesn't want to open its wallet at all, arguing the HOA isn't covered by our contract. It's like watching 2 people fight over who didn't order the appetizer, while the server, the court, is waiting impatiently with the bill. Now, imagine being the HOA here. One moment, you're arguing about whose hydrangeas are too close to the sidewalk, and the next moment, you're knee-deep in a federal court case. You've got one insurer pointing fingers at another, you've got angry residents asking why the community's even being sued, and oh yeah, you've got a child's family demanding justice. This isn't just legalese. This is real money, real liability, and potentially real damage to the HOA's reputation. Think about it. Who wants to live in a community where the board can't even manage insurance coverage without landing in a courtroom cage match? Now, here's a bit of legal trivia for you. Dog bites are one of the most common liability claims in the U.S. In fact, insurance companies pay out hundreds of millions each year in dog bite claims. Some states follow one-bite rules, where the owner isn't liable until the dog has shown aggression before. Others, like California, are strict liability states. That means if your dog bites, you're on the hook. No excuses, no second chances. So, in Lulu's case, the lawsuit didn't just go after the dog owners. Thanks to those HOA CC&Rs, it also targeted the HOA for failing to enforce pet rules and allowing this dangerous condition to exist on the property. And that's where things get juicy. Because if the HOA is liable, then USLI has to defend. But if Liberty had agreed to cover the HOA under their policy, USLI could have taken a back seat. But instead, Liberty basically said, "Not my circus, not my monkey." And USLI was like, "Oh, yes, it is. See you in court." So what's happening now? USLI has filed a federal lawsuit against Liberty. They're asking for a declaratory judgment, basically a legal ruling that says, "Judge, tell Liberty they have to defend and indemnify the HOA first." Why federal court? Because when insurance companies go head-to-head, it's usually bigger than state small claims. This is heavyweight stuff, and the precedent could ripple beyond this single HOA. Here's the kicker. This isn't just some random California drama. It's a warning shot for HOAs everywhere. Because if Liberty wins, insurers could start carving out even more exceptions in policies, leaving HOAs more exposed than ever. If USLI wins, HOAs might get stronger protection, but at the cost of insurers hiking premiums across the board. Either way, guess who ends up footing the bill eventually? You, the homeowner. Whether it's through HOA dues going up to cover lawsuits or insurance premiums skyrocketing, the money comes from your pocket. So yes, one dog bite in California could mean your HOA fees in Delaware, Texas, or Florida jump next year. Isn't that fun? Think of it like this. You and your roommate both promise to cover the electric bill. The bill shows up and it's massive because someone's been binge-watching Stranger Things with the AC blasting. Suddenly, you both start pointing fingers. That's your responsibility. No, it's yours. Meanwhile, the electric company doesn't care. They just want their money. That's this case in a nutshell. Right now, the trial clock is ticking. The underlying lawsuit against the HOA and the dog owners is still in play, and in September, this could all explode in court. Until then, the HOA is stuck in limbo, USLI is sharpening its legal claws, and Liberty is holding the line saying, not my problem. And all of this? Because of one dog bite. So, if this mess started with the dog bite, how exactly did the HOA's dusty rulebook turn into a weapon in court? Buckle up, because Fact 2 shows us how CC&Rs aren't just boring fine print. Sometimes they bite harder than the dogs themselves. If you've ever joined an HOA, you know the CC&Rs, covenants, conditions, and restrictions are the bedtime reading equivalent of warm milk and chamomile tea. Nobody reads them unless they have insomnia. Until suddenly, those boring pages are Exhibit A in a courtroom battle. And in the Palisades HOA number 3 dog bite case, the CC&Rs didn't just matter, they turned into the legal equivalent of a snarling Doberman on a short leash. Let's rewind. Remember Lulu, the child allegedly bitten by the pit bull? The lawsuit against the dog owners and the HOA didn't come out of thin air. It was rooted in the HOA's own governing documents. And here's the kicker. The HOA had already written rules that made this bite more than just dog meets kid, chaos ensues. The CC&Rs had strict liability provisions for pets. Translation, if your dog acts up, you're responsible. Period. No excuses. But that wasn't all. Those CC&Rs didn't just dump responsibility on the dog owners, they gave the HOA itself a role in keeping the community safe. If the board knew about dangerous pets, they had a duty to enforce the rules. Fail to act? Boom, the HOA's on the hook too. Which is exactly how they ended up sitting in court. Most homeowners think CC&Rs are about whether your mailbox can be mauve or your fence can be 6 feet instead of 5. But buried in those dusty paragraphs are clauses that assign liability. They're like little landmines waiting to go off. In this case, Article 8, Section 10 was the bombshell. It imposed strict liability for pet damages and injuries. That means, no, my dog never bit anyone before. No, she's usually so sweet. No, it was the kid's fault. Strict liability says, if it happened, you pay. Period. Now, to regular folks, that sounds harsh. But in legal land, strict liability simplifies things. It removes all the wrangling over intent or prior knowledge and says, the act alone creates liability. And when CC&Rs incorporate that kind of rule, they become a sword in the plaintiff's hand. Here's the twist, and it's a doozy. When HOAs adopt strict pet rules, they don't just control barking noise or poop pickup, they create enforceable duties. And if they fail to enforce those duties, courts may see them as partly responsible for the fallout. That's exactly what happened here. The lawsuit isn't just saying the Gruen's dog bit our kid, it's also saying the HOA knew or should have known about this risk, but they didn't act. In other words, the HOA's own rule book become the very rope plaintiffs use to drag them into the courtroom. It's like writing a diary about all the crimes you plan to commit, then acting shocked when the police use it as evidence. The HOA put the liability into writing years ago, and now it's biting back harder than the pit bull ever could. Think of it like this. If a babysitter agrees to watch a kid, and the kid ends up finger painting the walls with spaghetti sauce, who's at partly fault? Yep, the sitter. Why? Because they took on the duty of supervision. That's what the HOA did here. By writing into the CC&Rs that they'd oversee pet behavior, they accepted a babysitter-style responsibility. When something went wrong, the parents didn't just look at the dog owners, they also looked at the sitter. Here's the part that really makes homeowners sweat. The CC&Rs aren't just a neighborhood suggestion box. They're legally binding contracts. Courts enforce them the same way they enforce your mortgage or a lease. So when buyers sign on the dotted line at closing, they're basically saying, yes, I agree to all these restrictions, even the parts about dogs, cats, and liability I never bothered to skim. And that's why this case is so potent. The Gruens can't shrug and say, we didn't know. The HOA can't shrug and say, it's just rules. The CC&Rs have the force of law, and the judge will treat them like gospel. Now, here's where Liberty Insurance tried to play chess. They argued, the HOA isn't an insured under our policy. That sounds neat and tidy, except the CC&Rs are the very reason the HOA was tied to the dog bite in the first place. USLI, defending the HOA, pounced on this contradiction. If the HOA is being sued based on pet rules that trace back to the dog owner's obligations, shouldn't Liberty step in too? It's a clever trap. The CC&Rs, written to keep pets under control, are now the very rope dragging Liberty into the fight. Let's get practical. Why should you, random homeowner or HOA board member, care about the Palisades HOA's dog drama? Because this could be you. Got CC&Rs that say owners are liable for pets? Got a board that has the power to remove dangerous animals? Got insurers who love to say, not our problem when claims roll in? Congrats! You've got all the ingredients for your very own HOA insurance cage match. One bite, one scratch, one slip through the enforcement cracks, and suddenly your HOA dues are funding legal fees instead of landscaping. Here's the scary, funny part. Homeowners love CC&Rs when they keep the neighborhood tidy. Nobody likes dog poop on sidewalks or barking at 3 a.m., but those same CC&Rs can transform into weapons when the courtroom lights flicker on. They're double-edged swords, protection for some, liability for others. In Palisades, those rules were written years before Lulu's bite. But when her family's lawyers dug through the governing documents, they must have smiled, because suddenly, it wasn't just dog versus kid, it was documents versus HOA. And in court, paper often bites harder than teeth. Picture this, the HOA as the hall monitor in school, strutting around with a clipboard. One day, a kid runs wild and breaks a window. Who's in trouble? The kid, sure, but also the hall monitor because they were supposed to be watching. That's essentially what's happening here. The HOA's hall monitor role, written down in boring CC&Rs, is now Exhibit A and why they are liable. Another nugget. Strict liability clauses don't just apply to dogs. They can apply to property damage, vehicles, even activities. The same logic that put the HOA in this case could pull them into others. Skateboarding accidents, golf cart collisions, pool injuries. Anywhere the HOA promises oversight in the CC&Rs, they risk being dragged into lawsuits if things go south. So when you hear strict liability in those documents, don't yawn. Take a deep breath, because that's the sound of future lawsuits sniffing around. So here's the truth bomb. The CC&Rs that seemed like harmless community rules, they were the very trapdoor under the HOA's feet. The dog bite wasn't just about a pit bull and a child. It was about how a legal document, quietly filed and often ignored, suddenly turned into the courtroom's most powerful piece of evidence. The Palisades HOA never imagined Article 8, Section 10 would drag them into federal court. But here we are. And if you're in HOA, here's your wake-up call. Those CC&Rs you never read might already be holding your leash. So if the CC&Rs are the smoking gun, the next question is, who actually pulls the trigger first? Whose policy pays? Welcome to Fact 3, where insurance companies turn not it into a full-blown legal sport. Okay, we've established the dog bite happened. We've established the CC&Rs weren't just sleepy fine print, but courtroom dynamite. Now the question is, who pays first? Because if there's one thing scarier than an angry HOA board with clipboards, it's two insurance giants pointing fingers at each other like Spider-Man memes. Here's the setup. USLI, United States Liability Insurance Company, covers the HOA. They're on the hook because, well, the HOA is being sued. Liberty Mutual or its affiliate, covers the dog owners. They should be on the hook because the dog owners are being sued and the HOA is being sued because of the dog. Seems simple, right? Wrong. Because USLI says, hold up, Liberty. You're supposed to step up first. This is your circus, your monkeys, your pit bull. We're excess coverage. We only kick in after you've defended and paid. Liberty, of course, says, nope, the HOA isn't our insured. Not our problem. If you want to cover them, go for it. Don't drag us in. And just like that, we're in a legal version of hot potato. Except instead of a potato, it's a $1 million lawsuit, and nobody wants to get burned holding it. In insurance, this isn't unusual. It's called a primary versus excess coverage dispute. Primary coverage is like the first layer of defense, the policy that should respond immediately to claims. Excess coverage is the backup, the reinforcements that arrive if the battle gets too big. USLI is saying, we're excess. Liberty, you're primary. Do your job. Liberty is saying, the HOA isn't named on our policy. They're strangers to our contract. We cover our insureds, not their HOA. It's like two parents fighting over who has to change the baby's diaper. The mess is stinking up the whole room, but both are pointing at the other saying, your turn. Now, you might wonder, who cares who pays first, as long as someone pays, right? Wrong. The order of payment matters a lot. If Liberty pays first, it shields the HOA from immediate costs, and USLI can relax until limits are exhausted. If Liberty doesn't pay, USLI is left footing the bill for everything. Defense lawyers, settlements, damages. That's millions of dollars of difference. Think of it like being at a dinner with friends. One friend is supposed to cover the appetizers, the other the entrees. But if appetizer friend suddenly says, nah, I don't know those people at the table, not paying, then entree friend is stuck with the entire bill. Appetizers, entrees, desserts, the whole enchilada. That's the spot USLI doesn't want to be in. So, what did USLI do? They went to federal court. They filed a lawsuit asking for a declaratory judgment. Basically, Judge, please declare Liberty has to defend and indemnify the HOA before we do. This isn't about the underlying bite lawsuit. That's still ongoing. This is a side battle, insurer versus insurer, about duty to defend. And in insurance land, the duty to defend is the golden ticket. If you're stuck with that duty, you pay the lawyers, you pay the motions, you pay the depositions. Even if you ultimately don't owe damages, the defense costs alone can sink a ship. So USLI's move is strategic. Make Liberty carry the shield while USLI keeps its powder dry until later. Naturally, Liberty isn't taking that line down. Their argument is clean. The HOA isn't an insured under their policy. Their policy covers the dog owners, Adam and Erica Gruen, not the HOA board or the community. Unless the policy explicitly extends to any organization sued because of the actions of our insurance, Liberty can shrug and walk away. But USLI isn't buying it. They're pointing to the CC&Rs and saying, look, the only reason the HOA is even in this mess is because of the dog owner's actions. That makes this Liberty's mess too. It's a brilliant tug of war over wording. Does arising out of extend coverage to the HOA? Or is Liberty right that the HOA is a total stranger? Let's put this in everyday terms. Imagine you loan your car to a friend. They crash it into a lamppost. You both get sued, them for driving, and you for owning the car. Who pays the legal bills? Their insurer, right? After all, it was their driving. But now imagine the insurer says, we only cover the driver, not the owner. Suddenly, you're on the hook. That's the same vibe here. Here's the danger for HOAs across the country. If Liberty's argument sticks,
HOAs could be left naked every time they get dragged into lawsuits caused by residents. Dogs, parties, pool accidents, you name it. If insurers can carve them out, HOAs may find their own insurers always paying first, with no backstop. That means higher premiums, higher deductibles, and more special assessments when legal bills drain reserves. And homeowners? That's money out of your pocket, even if you never owned a dog. Insurance is basically a group project. Everyone promises to do their part, but when the teacher asks who turned in the assignment, suddenly everyone says, "Oh, not me. I thought you were covering that." Liberty's that guy in the group chat who forgot to upload the slides, leaving USLI scrambling at 3 a.m. to finish the project alone. Why does this matter beyond this HOA? Because if the court rules that Liberty does have to defend the HOA, it sets a precedent that insurers may be forced to cover entities indirectly tied to their insurance actions. That's huge. If the court rules Liberty doesn't have to, insurers everywhere may tighten their policy wording to make sure HOAs and other third parties are left out in the cold. Either way, the ripples spread nationally. Of course, while insurers squabble, the actual victim here, Lulu Pietrikakova, is still recovering, and her family is waiting for compensation. That's the sad irony of these disputes. The longer insurers fight about who pays first, the longer victims wait for justice. The court battle over who's on first may delay the actual resolution of the underlying claim. It's like two firefighters arguing over whose hose is bigger while the house is still on fire. So, fact number 3 is all about the order of battle. USLI says Liberty must defend first, Liberty says the HOA isn't theirs to defend, and the court is left to decide which giant has to pick up the shield. The answer will shape not just this case, but potentially how every HOA-related claim plays out in the future. So, the insurers are throwing legal elbows over who pays first. But who should the rest of us care? Because the ripple effects could shake every HOA in America. Fact number 4 is all about precedent. And trust me, the paw print left here could be massive.
All right, so far we've got a dog bite, 2 insurers at each other's throats, and an HOA dragged into court like the kid who swore he wasn't even there when it happened. But here's where things get real. This fight isn't just about one HOA, one policy, or one unlucky child named Lulu. Nope. This is the kind of legal showdown that could ripple across the entire country, reshaping how HOAs, homeowners, and insurers play ball. Welcome to the precedent paw print. Because when big insurers fight in federal court, the fallout doesn't just stay in California. It spreads like wildfire across HOA boardrooms nationwide. Let's start with a simple truth. Courts love precedent. Judges don't wake up each morning inventing new rules. Instead, they lean on past decisions like roadmaps. If a federal court rules Liberty owes a duty to defend the HOA here, guess what? That roadmap gets used in future cases whenever an HOA gets sued over a resident's actions. And suddenly, Liberty's little "not our insured" line stops working everywhere. Other insurers see the writing on the wall. They start rewriting policies to dodge HOA coverage more explicitly, or, brace yourself, they hike premiums to cover the new exposure. Either way, it doesn't stay in California. It trickles down to Delaware, Texas, Florida, Ohio, basically wherever HOA is room-free, which, spoiler alert, is almost everywhere in America. Picture this. The Palisades HOA number 3 drama ends with Liberty being forced to defend. HOAs across the country start asking, wait, can we lean on resident insurers every time we get sued because of something an owner did? Suddenly, boards feel bolder, lawyers start drafting new arguments, and insurers start sweating. But flip it around. If Liberty wins, insurers nationwide will treat this case like a green light. They'll say, see, we don't cover HOAs, period. That leaves HOAs holding the bag for more lawsuits, their insurers footing more bills, and here's the punchline, homeowners like you paying higher dues when premiums skyrocket. So either way, the dominoes fall. The only question is, which direction? Now, let's talk insurers. They watch cases like Hawks because one bad ruling can cost them millions. If Liberty loses, insurers may start tightening policy wording. Expect to see clauses like no coverage for homeowners associations or similar entities. Or third-party organizations are excluded from insured definitions. Translation? They'll build a moat so wide HOAs can't sneak in even if they try. On the flip side, if Liberty wins, HOAs and their insurers may demand stronger contracts to force residents to indemnify them for lawsuits. That means more fine print in CCNRs, more you must carry X insurance requirements for homeowners, and yes, more paperwork shoved into your mailbox. Here's the sneaky part. HOAs are often the testing ground for these fights. Why? Because they sit at the crossroads of private ownership and collective responsibility. They're like mini governments with real budgets, but also volunteer boards who never imagined they'd be starring in courtroom dramas. Insurance companies love to draw the line with HOAs because it sets a clear boundary. We'll cover our guy, but not the whole group. If courts let that slide, insurers get their wish. If courts push back, insurers re-strategize. Either way, the HOA becomes the guinea pig for legal experiments that echo across all liability law. Think about this. Short-term rentals, Airbnb, VRBO, are exploding in HOA communities. If a guest trips on a loose stair or gets bitten by a dog, the lawsuits can rope in both the owner and the HOA. This exact case could determine whether resident insurers like Liberty have to defend the HOA in those situations. If Liberty loses, HOAs nationwide may find themselves shielded by residents' policies more often. If Liberty wins, HOAs get hung out to dry. And that could make HOAs even more aggressive about banning short-term rentals, because every guest becomes a lawsuit bomb with no insurance backup. Imagine this court case as a dog park. USLI and Liberty are the two big dogs squaring up in the middle, teeth bared, tails stiff. The HOA is that nervous chihuahua on the sidelines wondering how it even got dragged in. Meanwhile, every other insurer in America is sitting on benches around the park, watching carefully to see which dog wins because they know the winner gets to set the pack rules for everyone else. Here's where it gets personal. You might be thinking, I don't even own a dog. Why should I care? Because your HOA dues are directly tied to how lawsuits play out. If insurers stop defending HOAs, guess who pays for lawyers? The HOA. And where does the HOA get money? Your dues. It's like being on a cruise ship where one passenger causes a problem and suddenly the entire boat has to chip in for repairs. You don't have to own the pit bull to feel the bite. Let's not forget about the lawyers. For them, cases like this are gold mines. They get to argue complex issues like duty to defend, arising out of liability, and insured versus additional insured. Meanwhile, billable hours pile up like HOA violation notices after a rowdy pool party. And once a precedent is set, lawyers across the country will cite it in their own cases, creating an endless feedback loop of litigation. Culturally, HOAs already get roasted for being power-hungry hall monitors obsessed with flower bed symmetry. Cases like this add fuel to the fire. Suddenly, HOAs aren't just the people telling you your fence is too tall. They're national case law test subjects, and that makes them both more powerful and more vulnerable. It's a weird paradox. HOAs may gain leverage over residents, but also risk becoming bigger lawsuit magnets. So here's the deal. Fact 5 isn't about the bite, the dog, or even just the Palisades HOA. It's about what happens after. Federal court rulings like this create paw prints that stomp across the entire HOA landscape. If Liberty loses, HOAs may lean harder on resident insurers, shifting costs outward. If Liberty wins, HOAs and their insurers will tighten the screws, passing costs inward, straight to you, the homeowner. So either way, the dominoes fall. The only question is, which direction? Okay, so precedent matters, but what about the original lawsuit that started it all? Let's zoom back in on the bite itself, the claims filed, and the messy web of accusations tying everyone together. That's fact number 5, and trust me, it's the juiciest part of the whole saga. All right, time to zoom the camera back in. We've been talking about insurers pointing fingers, HOAs buried in paperwork, and legal precedent shaking the ground under suburban lawns. But before the insurers even started their courtroom slap fight, there was the original lawsuit, the spark that lit this entire fire. And oh boy, this lawsuit isn't some one-note, dog bite happened, pay the bill claim. Nope. It's a buffet of allegations: strict liability, negligence, emotional distress, premises liability, nuisance. Basically, every possible way lawyers could describe, dramatize, and monetize a single dog bite. Let's break it down. It all starts with one dog, the Groon's pit bull. According to the lawsuit, this wasn't just a playful nip. The dog allegedly bit young Lulu Pietriakovo, leaving her injured. Now, in California, where this all went down, dog bites are no joke. It's a strict liability state for dog owners. That means, unlike other states where you might get a one-bite free pass, in California, the first bite is the last excuse. Dog bites equals automatic liability. So, the lawsuit was always going to go after Adam and Erica Groon, the dog owners. No surprise there. But the lawsuit didn't stop at them. The plaintiffs aimed higher, right at the HOA itself. Why? This is where things get legally delicious. Why sue the HOA? Because the HOA's CC&Rs gave them power over pets. They could have enforced leash rules, restricted dangerous dogs, or even banned certain breeds. The plaintiffs argue, you have authority, you didn't use it, and our child got hurt because of it. That makes you responsible too. In plain English, the HOA is accused of being asleep at the wheel. Think of it like a landlord who knows a tenant's apartment has faulty wiring, but doesn't fix it. When the fire breaks out, the landlord is just as liable as the tenant. The plaintiffs basically said the HOA failed to act as the neighborhood's watchdog, and now they're in the hot seat with the Groons. So what exactly did the plaintiffs file? Here's the menu. Strict liability, dog owners. Against the Groons. The dog bit, therefore the Groons pay. Clean, simple, brutal. Negligence. Dog owners and HOA. Groons, for failing to control or restrain their dog. HOA, for failing to enforce pet rules and letting a dangerous situation fester. Premises liability. The HOA owns and maintains common areas. If the bite happened there, plaintiffs argued the HOA failed to keep the area safe. Nuisance. The dog's presence was allegedly a dangerous condition that interfered with neighbors' right to safely enjoy the property. Lawyers love this one. It adds drama. Intentional infliction of emotional distress. Yep, this claim made the list. The idea, being bitten by a dog or watching your child bitten, is so traumatic that it rises to intentional harm. Does it stick? Maybe not, but in lawsuits, you throw spaghetti at the wall and see what sticks. Because, in lawsuits, more claims equal more leverage. Each cause of action is like another fishing line in the water. Even if 3 get tossed out, if one hooks the defendant, you've got a case. Plus, it makes settlement negotiations juicier. Defendants see the pile of claims and think, do we really want to risk all of this at trial? For the plaintiffs, it's about maximizing the chance of payout. For the defendants, it's about minimizing exposure. And for the lawyers, well, more claims mean more billable hours. Now imagine you're on the HOA board when this lawsuit lands. You've signed up to argue about landscaping budgets and parking passes, not to defend against allegations of negligence and nuisance in front of a judge. But here you are, named in a lawsuit involving a child's injuries and a pit bull with bad press. The HOA has to scramble, notify their insurer, USLI, hire defense counsel, answer resident questions like, wait, are my dues paying for this? And hold emergency meetings while trying not to panic. And let's be honest, nothing makes residents angrier than learning HOA funds might be spent on defending a lawsuit about someone else's dog. Here's the key. The plaintiffs knew the Groons might not have enough assets or coverage to pay a large judgment. Suing the HOA gave them a bigger pocket to reach into. HOAs have liability insurance, deeper reserves, and broader responsibility. By attaching the HOA, they made sure there were more potential payers at the table. It's lawsuit economics 101. Go after every party that might possibly owe you money, then sort it out in court. Now, imagine being in a group project in school. One kid forgets to bring the poster board and the teacher fails the whole group. Now everyone's mad, and the group leader has to explain why they didn't double-check poster boy. That's what's happening here. The Groons forgot the poster board, dog control, but the HOA, as the group leader, is accused of not managing the project properly. Result? Everyone's getting enough, in the form of a lawsuit. Let's pause on that emotional distress claim. Dog bites aren't just physical injuries. They can leave long-term trauma, especially for kids. The lawsuit argues that Lulu and her family suffered severe emotional fallout from the attack. And while juries may roll their eyes at some emotional distress claims, when it involves a child, sympathy skyrockets. That's why the claim matters. Even if damages for medical bills are modest, emotional distress claims can balloon into 6- or 7-figure awards if juries buy the narrative. That raises the stakes for everyone: Groons, HOA, insurers. So, the lawsuit is locked, loaded, and ready for trial. But what happens when the calendar flips to September? Fact number 6 takes us straight into the countdown to courtroom chaos, where strategy meets spectacle and everyone's bracing for impact. All right, friends, grab your calendars, circle September 2, and stock up on popcorn, because that's when this dog bite drama takes center stage in court. Forget Netflix courtroom thrillers like The Lincoln Lawyer. This trial is shaping up to be The HOA Lawyer, starring reluctant board members, bickering insurers, and one very unlucky pit bull whose name will forever live in litigation infamy. This isn't just a trial about a bite. It's the climax of months of finger-pointing, insurance dodgeball, and HOA panic. And now the stage is set for the countdown to courtroom chaos. September 2 isn't just another Monday after Labor Day. For the Groons, the HOA, and 2 heavyweight insurers, it's Judgment Day. On that date, the case of Webster et al. Versus Groon et al. Finally hits trial. Plaintiffs will roll out their story of a child attacked by a dog. The Groons will defend themselves as best they can. The HOA will try to convince the jury they're being scapegoated. And insurers? They'll be right there, behind the curtains, pulling legal strings and keeping calculators handy to tally potential payouts. If this were a boxing match, September 2 is round 12. Everyone's bloodied, tired, and out of excuses. Now it's up to the jury to decide who walks away and who gets KO'd. Let's take a closer look at the players walking into this legal theater. Plaintiffs, the Pietroyukovo family. Armed with sympathy and a child's injury, they'll argue the Groons and the HOA failed to protect Lulu. Expect emotional testimony, maybe even photos to drive home the trauma. Defendants, Adam and Erica Groon, they face strict liability under California law, meaning their defense options are limited. Best case, minimize damages by arguing the HOA shares blame. Defendant, Palisades HOA number 3, the HOA will stress that pet ownership lies with residents, not the association. But their own CCNRs, remember Article 8, Section 10? Could betray them. Expect a lot of "we did everything reasonably possible" arguments. Insurers, USLI and Liberty, officially, they're not the ones on trial in September, but unofficially, every word said in that courtroom affects their coverage fight. They'll watch like hawks, ready to pounce if testimony strengthens their case in federal court. It's like a reality TV reunion episode. Everyone has receipts, grudges, and something to lose. So, what can we expect each side to argue? Plaintiff strategy. Play up strict liability for the Groons. Quote, "The law is clear, their dog bit, they pay." Argue negligence on the HOA's part. Quote, "They knew or should have known this dog was dangerous." Emphasize emotional distress. A child's trauma resonates with juries. Gruen strategy. Accept strict liability, but shift blame. Quote, yes, we're liable, but the HOA failed to enforce its own pet rules. Downplay damages. Argue injuries weren't as severe as claimed. HOA strategy. Distance themselves. Quote, we don't control pets directly, owners do. Argue they had no prior knowledge of the dog being dangerous. Highlight insurance disputes to suggest blame is really between insurers, not them. Insurers' shadow strategy. Liberty hopes the jury keeps liability firmly on the HOA so they can argue not our insured later. USLI hopes the jury connects liability back to the Gruens, strengthening their Liberty pays first position. It's less about who's guilty and more about how the blame is divided, because division of blame equals division of payout. Let's be honest, trials aren't just about evidence, they're theater, and this one has all the dramatic ingredients. A sympathetic child victim, a scary pit bull, jurors' imaginations will do half the work. A faceless HOA board painted as bureaucrats who didn't do enough. Insurers in the shadows, maneuvering for dollars. Picture it, lawyers gesturing dramatically, jurors leaning forward, HOA board members sweating bullets. The HOA president probably wishes they were still arguing about mailbox paint instead of watching their community name flash across legal documents. Here's something people forget. Even before the trial begins, the costs are enormous. Defense lawyers don't work cheap. Depositions, motions, expert witnesses, it all adds up. And HOAs don't print money. Every bill for this lawsuit chips away at reserves or gets passed on to homeowners as higher dues. So even if the HOA wins at trial, they've already lost financially. And if they lose, those costs skyrocket. Insurance may cover some, but premiums will spike later. It's a lose-lose treadmill that never stops. You know those HOA board meetings where 5 people show up, everyone fights about where to put the holiday lights, and someone storms out? Imagine that, but with lawyers billing $500 an hour, reporters scribbling notes, and a judge banging the gavel. It's like Netflix took your neighborhood drama and gave it a courtroom budget. Here's the kicker. This trial isn't just about compensating Lulu or punishing the Gruens. It's about how responsibility gets divided between individuals, collectives, and insurers. That division will ripple outward. Homeowners might face stricter pet rules. HOAs might adopt harsher enforcement policies. Insurers will rewrite coverage language. This single trial could reshape how HOAs think about liability forever. Let's not forget the wild card, the jury. 12 random people who may or may not own dogs, may or may not trust HOAs, and may or may not think insurers are evil corporations who need to cough up cash. Their biases, sympathies, and gut feelings could outweigh all the legal nuances. A jury that loves dogs but hates HOAs, bad news for the HOA. A jury that fears pit bulls, bad news for the Gruens. A jury that distrusts big insurers, bad news for Liberty, even indirectly. It's the human element that makes trials unpredictable. Fact number 6 is all about the ticking clock. September 2 isn't just another date on a calendar. It's the moment this slow burn drama ignites. Plaintiffs, defendants, insurers, everyone has skin in the game, and the verdict will echo far beyond one California cul-de-sac. The trial is where theories become realities, where costs balloon, and where the HOA board's worst nightmare, courtroom spotlight, becomes real. Whatever happens, it won't just decide one dog bite. It will help define how HOAs, insurers, and homeowners handle liability for years to come. So, the trial countdown is on, but let's zoom out again. How exactly do HOAs and insurers enforce these rules, and what happens when homeowners push back? Fact number 7 takes us inside the world of fines, bans, and lawsuits, the not-so-friendly tools of HOA enforcement. All right, so we've walked through the bite, the lawsuit, the insurer's tug-of-war, and the looming trial. But let's hit pause and zoom in on a bigger theme. How HOAs actually enforce their rules when it comes to dogs, rentals, or just about anything else that threatens their carefully curated suburban utopia. Because here's the truth. HOAs don't just ask nicely. They've got teeth. And trust me, sometimes they bite harder than the dogs they're supposed to control. Welcome to the world of enforcement tactics. This is where community guidelines transform from boring documents into weapons of mass annoyance. Fines, bans, liens, and yes, full-on lawsuits. Let's start with the classic. Fines. HOAs love fines. Why? Because they're easy, they're instant, and they hit homeowners where it hurts, the wallet. Picture this. Your HOA has a rule that all dogs must be on leashes in common areas. You let Fluffy run free once. Boom, $50 fine. Do it again? Now it's $100. Keep ignoring it? Suddenly, it's $250 per day until Fluffy's leash is tighter than airport security. And that's not an exaggeration. Some HOAs escalate fines daily until compliance is achieved. Think of it like a parking meter, except instead of feeding coins, you're bleeding money straight into the HOA's budget. Now, in Delaware or California, courts will often uphold these fines, as long as they're spelled out in the governing documents and due process is followed. Translation, if it's written in the CC&Rs and you had a chance to fight it at a hearing, you're toast. Fines not working? Time for the next trick. Taking away amenities. This one stings. Imagine you're paying $300 a month in HOA dues, partly for access to the sparkling community pool, tennis courts, or clubhouse. You break the dog rules? Boom, your key card stops working. No pool, no gym, no Friday night bingo at the clubhouse. And if you've got tenants, it's even worse. Imagine trying to explain to your renters why their key fob doesn't work. Yeah, sorry, my HOA thinks you don't deserve chlorine or treadmills. Spoiler, your tenants won't be mad at the HOA, they'll be mad at you. Some HOAs even extend this punishment to owners directly. Forget about reserving the clubhouse for your kid's graduation party. Nope. Break the rules, and you're basically a community outcast. It's like being grounded, but instead of your parents, it's a bunch of retirees with too much time and too much authority. But fines and bans are just foreplay. The real hammer comes down when the HOA decides to sue you. Yes, HOAs can and will haul homeowners into court. The most common tool? Injunctive relief. That's a fancy way of saying, Judge, force this person to stop what they're doing. In our dog bite saga, the HOA didn't sue. They got sued. But in plenty of cases, HOAs go on the offensive. They'll sue to remove an unauthorized dog, force compliance with pet restrictions, or even evict tenants if lease violations pile up. And here's the kicker. Most CC&Rs include attorney fee provisions. That means if the HOA wins, you don't just pay your own lawyer, you also pay the HOA's. It's like losing a fight and then getting billed for your opponent's boxing gloves. But wait. It gets worse. If you rack up unpaid fines or lose in court, HOAs can place a lien on your property. What's a lien? It's like a scarlet letter on your house. It sits there until you pay, and when you try to sell or refinance, you can't close the deal until the HOA gets its money. It's the HOA's version of, we'll wait, but we'll never forget. And if the lien grows big enough, foreclosure isn't off the table. Yes, people have lost their homes over unpaid HOA fines. Imagine explaining that to your family. We lost the house because of Sparky's leash violations. Brutal. Since our original story ties back to Delaware, and HOAs nationwide should take notes here, let's talk state law for a second. Delaware requires due process before HOAs can enforce penalties. That usually means you get a written violation notice, you get a chance to appear at a board hearing, the board deliberates and decides the penalty. So no, HOAs can't just fine you out of the blue without notice. But if they follow the steps, courts will usually back them. Delaware homeowners often discover that fighting fines isn't about winning, it's about making sure the HOA played by the rules. If they did, good luck. HOAs aren't always content with fines, bans, and liens. Some get creative. Publishing violators' names in newsletters? Yes, public shaming still exists. Sending letters to employers? Rare, but it's happened. Towing vehicles when pets or tenants aren't registered. Requiring all leases to be pre-approved and rejecting tenants they don't like. It's like living in a high school where the principal can control your parking spot, your lunch table, and even whether you can show up at prom. Of course, homeowners don't just sit back and take it. Some push back, demand documentation. If the HOA didn't adopt the rule properly, fines may not stick. Challenge excessive penalties. Courts sometimes strike down unreasonable fines. Lawyer up. Even a threatening letter from an attorney can make a board think twice. Go political. Rally neighbors, replace board members, and change the rules from the inside. But let's be honest, most people don't have the energy, time, or money for long legal battles, and HOAs know it. That's why their enforcement game is so effective. It's easier to comply than to resist. Imagine an HOA as a squad of overzealous pet cops. Radar guns for barking, ticket pads for poop violations, a canine unit for, well, actually just Karen from the board with binoculars. They don't just enforce rules, they live for it. And when you slip up, you better believe the citation's already in the mail. Here's the real question. Why do HOAs go so hard on enforcement? The answer's simple: deterrence. They don't want every homeowner thinking they can bend the rules, so they make examples out of violators. It's neighborhood theater. Crack down on one poor soul, and everyone else quietly falls in line. It's like traffic cops setting up speed traps. They don't catch everyone, but the flashing lights make everyone slow down. Same logic here. Fact number 7 is all about the sharp end of HOA power. From fines to bans to lawsuits and liens, HOAs have a whole arsenal for making life miserable when rules are broken. And in cases like the dog bite saga, those tools, or the failure to use them, become Exhibit A in court. The HOA board doesn't just manage lawns and pools, they police behavior. And when they flex that authority, it's a reminder. In HOA land, rules aren't suggestions. They're ultimatums with dollar signs attached. So, fines sting, lawsuits drag, and liens haunt your property record. But where do HOAs actually get the power to do all this? That's fact number 8. We're pulling back the curtain on the Delaware legal backdrop that gives HOAs their enforcement superpowers.
We've talked teeth, literal ones from the dog and metaphorical ones from HOAs enforcing fines and lawsuits. But let's pump the brakes for a second and ask the million-dollar question. Where do HOAs even get this power from? Because let's be honest, sometimes it feels like HOA boards just sit around inventing rules. No pink flamingos on lawns, no barbecue smoke on Tuesdays, and oh, by the way, your tenant has to pass a background check. But spoiler, they're not winging it. HOAs are creatures of law, and in Delaware, that law has a name scarier than the HOA itself. DUCOA, the Delaware Uniform Common Interest Ownership Act. Sounds boring, right? Wrong. This little legal framework is the rule book for the rule book. And in the HOA dog bite saga, and rental fights, and every other HOA mess, it's the backdrop that decides what's legal and what's laughable. DUCOA, pronounced DUCOA if you want to sound fancy at board meetings, is the state law that governs common interest communities in Delaware. Think condos, townhomes, and, you guessed it, HOAs. It covers everything. How HOAs are created, how boards are elected, how rules are adopted and amended, how money is handled, and, yes, how enforcement and liability work. Without DUCOA, HOAs would be rogue mini-governments writing their own constitutions with no oversight. With it, they've got structure, process, and, most importantly, legal backup when they enforce rules. Here's the kicker. In Delaware, your HOA's documents aren't just suggestions. Courts treat them as binding contracts. That means when you bought into the community, you didn't just get a house, you signed up for a legal agreement. The CCNRs, bylaws, and rules, they're enforceable like a lease or a mortgage. Judges don't care if you read them or not. Ignorance isn't a defense. You signed, you're bound. So when the Palisades HOA number 3 in California, but imagine it in Delaware, enforces pet rules or rental limits, they're not just being picky. They're executing a contract that courts will uphold. But what if your HOA suddenly decides, hey, no more rentals ever, or no dogs over 25 pounds? They can't just scribble it in the newsletter. DUCOA requires proper procedure for amendments. That usually means notice to homeowners, a vote, often a supermajority, and recording the amendment with the county. Skip a step? Boom. The amendment may not be enforceable. This is where homeowners sometimes find leverage, not in the substance of the rule, but in the process of how it was adopted. Delaware law also requires HOAs to give homeowners notice and an opportunity to be heard before enforcing penalties. Translation: they can't just fine you $500 because your dog barked at 3 a.m. They have to tell you what you did wrong, offer you a chance to explain yourself at a hearing, and then decide on penalties. Do they always listen with open hearts? Please. But legally, they have to go through the motions. And if they don't, you might have a case to challenge the fine. Here's where things get spicy. Suppose you bought into a community when rentals were allowed. Years later, the HOA bans them. Are you exempt? In Delaware, grandfathering isn't automatic. Some courts lean toward fairness and say owners before the rule shouldn't be penalized. Others enforce the rule across the board. It depends on wording, timing, and sometimes just the judge's vibe that day. So if you're banking on being grandfathered in, don't assume. Check the exact amendment language or prepare for a fight. Here's the brutal truth. When documents are clear and procedures are followed, Delaware courts almost always side with the HOA. Why? Because when you bought your home, you agreed to shared governance. Judges see it as a deal you signed on to voluntarily. It's not oppression, it's contract law. Harsh? Maybe, but legally sound. That's why HOAs can feel unstoppable. They've got state law and court precedent backing them up like a personal hype squad. Let's break it down with an analogy. Buying into an HOA is like joining a gym. Sure, you own your membership, but you also agreed to follow their rules. You can't smoke cigars in the sauna or bring a pack of wolves to yoga class just because you paid. Same with HOAs. You own your home, yes, but your rights exist inside a framework you agreed to, and Delaware law makes sure those rules actually stick. Now, here's where Delaware is unique. Some states, looking at you, Florida, regulate HOAs heavily, with endless statutes dictating what they can and can't do. Delaware, not so much. Instead, Delaware gives communities lots of autonomy. As long as they follow DUCOA's framework, HOAs can shape rules however they want. That means two HOAs a mile apart could have totally different rental restrictions, pet policies, or enforcement styles. It's like one gym banning chalk and another handing out free chalk bags. Delaware says, your house, your rules. Just follow the process. But don't despair entirely. DUCOA does give homeowners tools to push back. You can request HOA records and meeting minutes. You can demand proof that amendments were adopted correctly. You can petition for votes to replace board members. And yes, you can sue, though it's costly. So while HOAs have a ton of power, they're not untouchable. The law allows pushback if you've got the energy and resources. Think of DUCOA like the parent in a chaotic household. The HOA kids fight constantly, the homeowners complain, and the insurers hover like moody teenagers. DUCOA steps in not to pick sides, but to say, follow the rules or no one gets dessert. It doesn't care if you're mad about curfews or screen time. It just enforces structure. Fact number 8 is the backbone of the whole saga. HOAs don't make up power out of thin air. In Delaware, DUCOA hands them the authority and courts treat CC&Rs as binding contracts. That means documents equals law of the land, amendments must follow process, enforcement must give due process, grandfathering is a maybe, not a guarantee, and courts usually side with HOAs if they play by the book. So whether it's rentals, pets, or landscaping, the HOA's power is real, backed by state law, and enforceable in court. The only real wiggle room is catching them when they skip a step. So now we know HOAs have legal backup for their bite. But here's the twist. Homeowners aren't helpless. Some get clever, some get sneaky, and some push loopholes harder than a dog trying to dig under a fence. That's fact 9, the wild world of workarounds and loopholes.
Okay, so we've established HOAs have teeth. Legal teeth, financial teeth, even emotional teeth. Ask anyone fined for the color of their shutters. But here's the part HOA boards don't like to admit. Homeowners aren't powerless. In fact, some homeowners get real clever. They find workarounds, loopholes, and gray areas that make HOA boards grind their teeth like teenagers caught sneaking in after curfew. This is fact number 9. The sneaky ways homeowners outsmart HOAs, sometimes winning battles that look unwinnable on paper. Every HOA rule is only as strong as the process used to adopt and enforce it. And guess what? HOA boards aren't perfect. Maybe they forgot to give proper notice before a vote. Maybe they miscounted ballots. Maybe they didn't file the amendment correctly with the county. Enter the clever homeowner. Instead of arguing against the rule itself, they argue the process was flawed. Courts eat this up. Judges might hate messy dog cases, but they love clean procedural mistakes. Think of it like fighting a speeding ticket not by saying, I wasn't speeding, but by saying the officer didn't calibrate his radar gun. Technicality wins even if you were doing 95 in a school zone. We touched on this earlier, but homeowners love this move. When an HOA passes a new restriction, like banning rentals, outlawing certain dog breeds, or limiting paint colors, existing owners often argue they should be grandfathered in. Sometimes it works, sometimes it doesn't. Delaware law doesn't guarantee it, but judges sometimes lean on fairness. After all, if you bought a house expecting to rent it or own a German Shepherd, is it fair for the HOA to suddenly say no? Homeowners who play the grandfather card effectively force the HOA to either compromise or spend a ton of money proving the rule applies retroactively. Either way, it's leverage. Here's a spicy one. Say an HOA bans certain pets. A homeowner wants a banned dog anyway. Solution? Rent the unit out to a tenant who owns the dog. Then argue the HOA is discriminating against renters if they enforce pet rules unevenly. It's sneaky, it's messy, and it drags fair housing laws into the mix. HOAs hate this because once discrimination claims are raised, boards start sweating bullets and calling their lawyers at $500 an hour. This one's practically legendary. HOAs try to ban pets. Homeowners whip out ESA letters like Uno reverse cards. Thanks to federal fair housing laws, emotional support animals are exempt from most pet restrictions. Doesn't matter if the HOA has a 25-pound weight limit, a 2-pet max, or a no pit bulls clause. If you've got a legitimate ESA letter, they usually have to let it slide. Of course, legitimate is doing a lot of work there. The internet is full of sketchy sites handing out ESA certificates for $79.95. HOAs know it, courts know it, but challenging it can get them into ADA fair housing quicksand. So many HOAs just cave. When HOAs ban rentals, homeowners often pull the old loophole shuffle. Call it a long-term guest instead of a tenant. Sign house-sitting agreements. Do short-term rentals under the radar with different platforms beyond Airbnb. Or, my favorite, rent to a family member and call it family occupancy. HOAs try to sniff this out, but unless they want to surveil your property 24/7, it's hard to prove. Enforcement turns into a game of cat and mouse, with homeowners always one step ahead. This one is powerful. If a homeowner can show the HOA enforces rules against them, but not others, courts may strike the rule as arbitrary. For example, if the HOA fines you for having a pit bull but ignores 3 other pit bulls in the neighborhood, you've got ammo. Same with rentals, paint colors, or any other restriction. HOAs must enforce consistently, or they risk looking biased. It's like being sent to detention while your buddy skips class every day scot-free. The teacher loses credibility fast. Here's the nuclear option. Don't fight the HOA in court, fight them in politics. Organize your neighbors, call a special election, and vote the current board out. Replace them with people who share your vision, whether that's pro-rental, pro-dogs, or pro-flamingo lawn decor. It sounds dramatic, but it happens more often than you'd think. HOAs are democracies at the end of the day, albeit cranky ones. If enough people are fed up, the board can be flipped like a pancake. Think of HOAs like video game bosses. They've got layers of armor, scary powers, and dramatic music when you enter their lair. But here's the thing, every boss has a weakness. Maybe it's fire, maybe it's ice, maybe it's technicalities in DCO. The clever player, aka homeowner, doesn't fight fair. They find the loophole and exploit it. Suddenly, the giant HOA dragon collapses because you spammed the right move. Now let's tie this back to the USA versus Liberty dog bite case. Imagine if the Groons had tried some of these loopholes, claiming the dog was an ESA, arguing the HOA had selectively enforced leash rules, saying the HOA amended rules improperly. Any of these could muddy the waters enough to shift blame, reduce damages, or at least buy time. And insurers, they hate loopholes because loopholes create uncertainty, and uncertainty means longer, more expensive cases. Of course, playing games with the HOA isn't risk-free. Courts don't like homeowners who abuse loopholes just to dodge responsibility. Get caught faking an ESA letter, and suddenly the HOA looks like the good guy. Overplay your hand, and you may end up paying more than if you just complied. It's a balancing act. Use the loophole wisely or watch it snap shut on you like a bear trap. Fact 9 is proof that homeowners aren't just passive victims of HOA power. From technicalities to ESA cards to boardroom coups, there are ways to push back, dodge, or outright outsmart the board. Do HOAs usually have the upper hand? Absolutely. But every Goliath has a David, and sometimes all it takes is a sling made of paperwork and a good lawyer. So next time your HOA slaps you with the violation, remember, somewhere in the fine print may be the crack you can slip through. So, we've covered loopholes, lawsuits, and legal smackdowns. But here's the million-dollar wrap-up. What does this whole saga really mean for the future of HOAs, insurers, and homeowners everywhere? That's fact number 10, the grand finale where we connect the dots and reveal the big picture. All right, let's zoom all the way out. We've dissected the bite, the lawsuit, the insurer's slap fight, the looming trial, the Delaware backdrop, and even the sneaky loopholes homeowners use to poke holes in HOA armor. But now it's time to ask the billion-dollar question. What does all of this actually mean for HOAs, homeowners, and insurers across the country? Because, let's be real, this isn't just a California HOA problem. It's not just about one pit bull, one unlucky child, or even 2 giant insurers squaring off. Nope. My friends, this is the blueprint for the future of community living. And whether you're in Delaware, Texas, or the land of Florida man, the ripple effects are coming for your neighborhood too. Once upon a time, HOAs were basically glorified garden clubs. They argued about lawn care, collected dues, and mailed out newsletters nobody read. Today, they're legal entities drowning in lawsuits. From dog bites to rental bans to disputes over paint colors, HOAs are being dragged into court at a record pace. Why? Because they're the deep pocket scapegoat. Lawyers know homeowners might be broke, but HOAs? They've got reserves, insurance, and mandatory dues from dozens or hundreds of residents. That makes them irresistible targets. And after cases like this dog bite saga, expect that trend to accelerate. Every plaintiff's lawyer is taking notes. Quote, if the HOA has even a sliver of responsibility, rope them in. Unquote. Now, let's talk insurers. You think USLI and Liberty are fighting hard in this case? Wait until you see the industry fallout. If Liberty loses and gets stuck defending the HOA, insurers across the country will scramble to rewrite their policies. Expect to see more exclusions, tighter definitions of insureds, and less wiggle room for HOAs to sneak into coverage. Translation: premiums go up, coverage goes down. Homeowners and HOAs foot bigger bills. If Liberty wins, insurers still celebrate because it gives them precedent to carve HOAs out even more aggressively. Either way, the insurance industry walks away stronger while homeowners and HOAs feel the squeeze. It's like when cell phone carriers fight over who has the best coverage. You know who wins? Not you. On the flip side, HOAs themselves will look at this case and go, yikes, if we can get sued for not enforcing rules, maybe we should enforce harder. That means stricter pet policies, more leash patrols, tougher rental approvals. Boards won't just enforce to be nosy, they'll enforce to cover their own butts in court. Picture Karen from the HOA with a clipboard at every dog walk, snapping photos like a paparazzi. Not because she hates your Labradoodle, but because she's terrified of being Exhibit A at the next trial. And here's where it lands hardest. The average homeowner. You, me, anyone who buys into a community. Higher dues to cover rising insurance costs, more rules to prevent liability, less flexibility with rentals, pets, and property use, bigger fights when insurers duck responsibility. You don't have to own a pit bull to feel the bite. Every lawsuit, every precedent, every insurance squabble trickles down into your monthly bill. Why are we talking Delaware so much? Because it's not just another state. It's a legal lab. Delaware law gives HOAs broad power, and its courts set precedents that other states pay attention to. If Delaware courts back HOAs hard, expect other states to follow suit. If Delaware homeowners win more challenges, other states might loosen the leash on boards. Either way, Delaware is the canary in the coal mine of HOAs. Let's step back from the law and look at culture. HOAs already have a bad rep. The nosy neighbor stereotype, the paint color police, the eternal enemy of inflatable lawn Santas. Cases like this only cement that image. Every news headline about HOAs being sued over dogs, rentals, or pools reinforces the idea that HOAs are mini dictatorships. But here's the twist. Some people actually see HOAs as heroes for keeping communities safe. If this case ends with the HOA found liable, expect homeowners to demand even stricter enforcement. Nobody wants their kid to be the next Lulu. Suddenly, the same board that banned your trampoline looks like the neighborhood's protector. It's a weird paradox. HOAs may be hated more than ever, while also being needed more than ever. Picture HOAs as reluctant superheroes. They didn't ask for this. They just wanted to collect dues and argue about mulch. But then the courts said, if you don't stop the villains, aka dangerous pets, you'll be liable. Now, the HOA is Batman with a clipboard, patrolling the neighborhood, writing citations instead of throwing batarangs. Nobody loves them, but when chaos erupts, they're forced into action. Remember those loopholes from Fact 9? Expect homeowners to push them even harder after this case. If HOAs crack down, homeowners will fight back with ESA letters, technicality defenses, and rental shuffles. The result? Endless legal chess. HOAs tighten rules, homeowners find new loopholes, courts referee, insurers cash in. Rinse and repeat. It's less about harmony and more about who has the sharper lawyer. Here's the saddest part. HOAs were supposed to build community. Neighbors working together, pooling resources, keeping things nice. But cases like this turn neighbors into adversaries, boards into cops, and insurers into shadow referees. Instead of block parties, you get board meetings. Instead of trust, you get lawsuits. Instead of love thy neighbor, you get see you in court. Community spirit dies a little every time these cases explode. Fact number 10 is the grand finale, the aerial firework that lights up the whole sky. HOAs are being sued more, becoming litigation magnets. Insurers will react by raising costs or cutting coverage. HOAs will enforce rules more aggressively to dodge liability. Homeowners will feel the pinch through higher dues and stricter rules. Delaware's legal precedents could ripple nationwide. The cultural battle, HOA villains versus HOA heroes, will only intensify. This dog bite case is more than a lawsuit. It's a warning shot, a preview of how liability, insurance, and community governance collide in the modern HOA era. And like any good HOA story, it ends not with a neat resolution, but with more questions. Who pays? Who's responsible? And how much more will homeowners have to sacrifice just to live in peaceful communities? The big picture is simple but sobering. HOAs are no longer just about lawns and pools. They're about law and liability, and that changes everything. So what do you think? Are HOAs overstepping, or are they just stuck playing referee in a game nobody wins? Drop your thoughts in the comments because trust me, this debate is just getting started. And if you've survived an HOA nightmare of your own, we want to hear it. Smash that like button, subscribe for more HOA wars, and join us next time as we dive into the next jaw-dropping case where suburbia meets courtroom chaos. Until then, leash your dogs, read your bylaws, and remember, in HOA land, the drama is mandatory.